Uh, Thanks everyone for joining us today. This is the second webinar in the series on IP education that CRI is sponsoring. So today we have two lawyers from an IP firm that works closely with CRI on different IP matters, and they will talk about IP as it relates to software that is also tied to, say, like a drug discovery or like more life sciences or health sciences kinds of applications and projects. Please go ahead, Dana and Laura.
Okay, thank you very much, VS. Well, everyone, it's a pleasure to be here and speak with you. I'm Dana Gordon. I'm a partner at Foley Hoag. We work with CRI on many matters. And today, as VS said, we're going to be speaking with you about IP issues related to platform technologies, which could sound in software or biotechnology, and the model would apply to any technology. So with that said, I'll let my colleague Laura Zorek introduce herself.
Thanks, Dana. I'm Laura Zorek. My background is in organic chemistry, and I'm an associate here at Foley Hoag and have been practicing here at Foley for 10 years.
Thanks, Laura. Okay, you could advance the slide, please. So as we said, we're going to be talking about platform technologies and intellectual property issues that relate to them, which includes technology transfer, startup companies that might be involved, etc. So the things that we intend to discuss are what can be patented, and as patent practitioners, when we think about what can be patented, what we're really focused on is what sort of patent claims can we get granted in the various jurisdictions in which the university, perhaps in consultation with a licensee or optionee, decides to pursue patenting. Another related question is what, if anything, can be protected long-term as a trade secret or know-how? Trade secret and know-how, these are terms that lawyers use that you're probably familiar with, but just to provide a little bit of clarity, they're terms for any information that provides a scientific or business advantage that you don't place in the public domain. So one virtue of trade secret protection is that it has an indefinite term. It can last forever, essentially, so long as you don't put the information in the public domain and no one else independently develops it. However, in the context of academic research and tech transfer, trade secret and know-how IP is of lesser importance because, of course, as you all know, academics need to publish, faculty need to publish, and grad students and postdocs need to publish for future career prospects. And there are complexities associated with research done using federal funds vis-a-vis the ability to rely on trade secret protection. There's an important act of federal legislation that came into effect in 1980, I believe, called the Bayh-Dole Act. And this act spurred the academic tech transfer industry or function across the country because it said that universities could own the inventions coming out of federally sponsored research so long as the universities comply with various rules. Those rules include filing patent applications on the inventions within a set period of time. So the universities are highly incentivized to file patent applications because then they get to own the IP, which they can then hopefully license, etc. So you probably won't hear a tremendous amount more about trade secrets. That's why I just spent a moment or two providing some detail. And then the last thing, so the first thing, what can be patented? Is trade secret protection or know-how even viable here? And what can be commercialized? I should say that some aspects of technology are not suitable for patenting, and therefore the university would not file a patent application on that particular technology. Therefore, the technology would remain a trade secret or be licensable know-how unless it were placed in the public domain through some other mechanism. Okay, the next slide, please. All right, and this is a slide that's just meant to help set the sort of hypothetical or framework for our discussion. An example of a platform technology at the intersection of life sciences and artificial intelligence. So what we've got here are new predictive approaches for identifying novel targets or repurposing known compounds, identifying new chemical space, and virtual screening. These sorts of activities are being practiced extensively in companies as well as in academia. So this is a real world hypothetical. Many companies and university research labs are working on technology of this type. And so the questions that we'll walk you through are, what does patent protection look like here? And again, that trade secret protection is not suitable for technology developed with federal funding, and it's also incompatible with the publish or perish academic environment. So hopefully there's a clear picture of the hypothetical. And with that, Laura is going to give us all a primer on patent law. Next slide, please.
Thank you. Okay, so in order to begin talking about platform technologies and what can be protected from using patents, we thought we'd give a little introduction to patent law. So at the outset, what is a patent? Sometimes it's easier to define what it is not. It's not a right to do something or to practice something, but rather it's a right to exclude others from making, using, or selling an invention that's covered by a patent in whatever jurisdiction has granted the patent. So the boundary lines of your property, of your right to exclude, are defined by the claims of the patent. Now, there are primarily two parts of a patent or patent application. The first and usually larger part of your patent is the specification. That can include things like a discussion of the background technology, what the state of the art is. It may include definitions that are used, definitions of terms that are used in your claims, and descriptive embodiments of the invention. And your specification also typically includes some experimental procedures outlining how it is you put your invention into practice. And then, of course, the second part is the claims, which again define the limits of your right to exclude. And then optionally, your patent application or patent can include drawings that might show exemplary embodiments or results of experimental results of experiments. So this next section could be easily an entire webinar, if not an entire law school course, but just briefly, the requirements for patentability of an invention include novelty. So your invention must be new. It must be also non-obvious over the universe of prior art. And it must have utility, or it must, in other words, it must be useful. Your specification must describe the invention sufficiently to enable a person of skill in the art to practice the invention, and it must show that you're actually in possession of the invention. And finally, the invention itself, the subject matter you're claiming, must be in a category of subject matter that is considered patentable. So next slide, please. Great. Now, we can think of patents falling into two big categories. The first category is composition patents. So composition patents claim something tangible. So it could be an antibody or a device, some sort of a material, a chemical compound. And then the second category would be an application patent. So something that could be a method of using or a method of making. And often these are tied to composition patents in that the application claims a way to make or use the tangible thing. So between those two categories, we consider composition patents to typically be more valuable than application patents. And this is largely tied to the ability to enforce a composition patent. So for compositions of matter, possession by a third party, unauthorized possession, constitutes infringement of the composition patent.
And that would be true if it were an antibody or a widget, right? Any tangible thing, it's much easier to show infringement.
That's right, yeah. And in the next slide, we can get into a little more detail about enforcement and what is required for infringement. So as I mentioned on the prior slide, composition patents are easier to enforce because you just have to show that a third party made, used, or sold the widget. It doesn't matter if that third party made the widget in a different way than you made it. It doesn't matter if they're using it for an entirely different purpose. Really, it's just that they have the same thing that is in your claims. And so the takeaway from that is that a composition of matter patent or a composition patent blocks all unauthorized uses of the claimed thing. So let's contrast that with an application patent. Let's say you're claiming a method of using a thing. In order to show infringement of that application patent, you need to show that the third party had possession of the thing that is used in the claims, and also that they're practicing the claimed method in the same way that is described in your claims. So method patents typically recite multiple steps, and in order to show and prove infringement, what you need to show is that each step of your claimed method is performed by a single actor. So I guess to give an example, let's say you're, compare a composition patent where maybe you've claimed a compound versus a method patent where you have steps that are like, a method of contacting a cell with the compound. That would be step A, contacting, and then step B could be measuring some output. To prove infringement of the application patent, you need to show that both that the unauthorized third party has done the contacting the compound with the cell and has also done the same measurement that is required in your claim. So you can see how that's like a higher burden to prove infringement of an application patent.
Yeah, in the diagnostic space, there are oftentimes situations where one entity will acquire the sample, for example, and then ship the sample to a third party, and the third party does the evaluation of the sample to determine whether or not the person has the malady or whatnot. And in that case, what Laura was just describing is very important because as I just described, there is no single actor who has practiced both of the steps in the claim, and therefore, according to US law, there's no infringer. So that's important. Please go ahead.
Of course. So I guess fitting this into the topic we're discussing today of platform technologies, that leads us to the question of, in the composition versus application dichotomy, where do platform technologies fall?
And then there's the overarching issue of subject matter eligibility.
Right.
make sure that we explain what is not patentable for that.
Um, so let's see, I think this is me here. So before we dive back into platform technologies, you know, you all faculty members, you might need to ask yourself, is my invention ready to be patented? So the questions you can ask yourself to make that determination are, have you put your invention into practice? Have you demonstrated it in the lab, for example, or have you described it sufficiently in order to show that you actually possess your invention and to enable a person of ordinary skill in the art to perform your invention? Timing wise, there's always a consideration of filing early, which gives you the benefit of an earlier filing date. That might mean that there's less prior art available out there, like especially if you're in a crowded technology space, but where publications are coming out rapidly. You can imagine you would benefit from an earlier filing date because any publications that come later will not be prior art to you. The flip side of that, though, is that if you file too early, you may not have enough exemplification to get the breadth that you want out of your claims. So a later filing date, you may benefit because you have more exemplification, and then you can get broader claims. The most important consideration here about timing, though, is that you want to make sure you're not creating any prior art for yourself. So you must file before there's any public use or public disclosure of your invention. And public disclosures are something that academics run into all the time, right? Whether you or a student are presenting at a conference, whether it's a poster or a talk, whether a student is defending their thesis or you're publishing a paper, you want to make sure that your patent filing happens before that date.
So it's very important to work closely with CRI and keep them informed of your technology as it develops and your plans to make any public disclosures. And we'll be talking about that on the next slide. I think that what you just heard from Laura should make clear to all of you that she's very skilled and experienced with all of these issues and very cautious. And I'm sure that you'd be happy to work with her on any of your technologies. Okay, so I just want to revisit the subject matter eligibility issue because that was a filter that is very important for platform technologies in particular. You know, we talked, Laura just explained to all of us the sort of fundamental requirements: novelty, non-obviousness, enablement, written description. But there's a sort of overarching issue of, well, what is even eligible for patenting? And the system in the US has diverged from the rest of the world in a way that is particularly relevant to platform technologies. Without getting into a lot of detail, there are some things in the US that are just not going to be patentable. Algorithms are not patentable. What the Supreme Court considers laws of nature and abstract ideas are not patent eligible in the US, even if they're novel, non-obvious, enabled, and adequately described. You should never be able to get a US patent with a claim to a law of nature, an algorithm, or an abstract idea. What the Supreme Court, which is made up of non-scientists, thinks is a law of nature is probably different from what you as scientists think is a law of nature. So the way that I at least think about this is they're fundamentally concerned about overly broad patents that are going to foreclose any sort of innovation in a particular area. The use of an algorithm to do anything is too broad. The use of an idea, which the Supreme Court would think of as abstract, to do anything is just too broad. They're not going to let you have a patent on that. So you have to bring down your algorithm, your abstract idea, your platform to something that's more concrete. So the algorithm, the use of the algorithm can still be patented, but it has to be tied to something more concrete. Okay, so with that said, how working at Northeastern, or and this is true for any academic institution in the US as far as I can tell, how do you pursue patent protection on inventions that you make in the course of your research activities? Well, the first step, as we alluded to moments ago, is you need to contact CRI. The patenting process is a collaboration among you, the faculty, postdocs, and students, CRI, and outside counsel once the decision is made to pursue a filing on technology at a particular time. So as you appreciate, the CRI staff, while tremendously experienced, helpful, and dedicated, they don't know what you're up to unless you tell them. So the onus is on the academic researchers to inform CRI, and the standard mechanism for doing that is to complete and submit what we think of as IDFs, invention disclosure forms. You need to do that with enough runway before you're going to make a public disclosure, or before you're going to have a manuscript published in Nature or any other journal, that to allow for evaluation, retaining outside counsel, give outside counsel a chance to understand the technology, prepare a fulsome patent application, and get it filed. These are very important. I don't want to give you the impression that if you forget to talk to CRI until a couple of days before a disclosure, that all is lost. We can file very quickly limited patent applications to protect the subject matter that you are about to disclose, but it's always better to have some lead time so that there can be a more fleshed out filing made before the disclosure. So then, just to drive the point home, the Northeastern team is not going to know about your technology unless you submit an IDF. And the next slide, please. Okay, so how do you do it? There's a collective determination of timing and jurisdictions. I want to make sure that we end up talking about the technology, so let's just move through this bit a little more quickly. An initial filing will almost always be a US application, what's known as a provisional application, and then later there will be decisions made about in which jurisdictions to file. Cost, of course, is a factor in making these sorts of decisions, and the university is in the business, so to speak, of technology transfer, and so the goal is to find an optionee for the technology or a licensee, and the optionees and licensees then help to cover or do cover the expense associated with the patenting. There's always going to be an assessment of commercial value, both by potential third parties that might option or license the technology, and also by the university in the first instance on whether or not to file a patent application. Okay, next slide, please.
Okay, great. So when we consider having patented a platform technology, we can consider what the next steps are for Northeastern, and how the platform technology is put out to potential partners or licensees. So how would Northeastern transfer this technology? Typical routes would include licenses to, for example, a startup or an option. There's also sponsored research agreements that could be entered into. And then let's say you've claimed and patented a predictive platform. You could license that to a startup company. or potentially offer it as a service. But here we would caution that Northeastern cannot become a for-profit enterprise. It doesn't want to lose its nonprofit status. So the creative ways to structure this type of transfer would be through a sponsored research agreement, for example.
Yeah, the sponsored research agreement is particularly appealing in a case where you have a startup that doesn't really have any personnel, doesn't have a physical space yet, for example, and the researchers in the academic lab have everything set up to continue to run the platform technology. They're the people who know how to do it best in the world. And so a sponsored research agreement can be a way for the startup to provide additional research funding to the lab. The lab can work on that technology in a way directed in part by the startup. And then the university would, well, I won't discuss the ownership yet, but there are ownership issues that relate to that Laura will tell us about soon.
Great. So so consider maybe the scenario where there's a license to a startup, and maybe that startup is using some sort of predictive platform to focus on, one or two targets to enable, clinical development and IND studies. So I guess comments here would be that Northeastern is, of course, sensitive to the budgetary constraints of startups. And so Northeastern wouldn't want to get into a license where, like an exclusive license where the predictive platform is exclusively licensed to a single startup that's only going to focus on 1 to 2 targets. They would want to remain a little bit nimble and be able to license this technology to additional startups so that it can be used for further target development. So this is all would be outlined in the terms of whatever the agreement is. Again, it would be like a non-exclusive license in this case. And then the question about who owns the IP coming out of such a collaboration. Ownership of IP really depends on inventorship. And so you ask the question then, who really invented the discoveries that are coming out of this, what I'll call a collaboration or license agreement. So typically these agreements outline results that are from the licensor, results that are from the licensee, and then co-owned, like jointly owned results. So have I missed anything about that?
No. I think I'd just like to add that the point that Laura has made about perhaps licensing 1 or 2 targets to a startup and then licensing other targets to another startup is very important. I mean, we're talking about a true platform technology. So if we keep it focused on the hypothetical where you're screening small molecules, let's say, for therapeutic potential, that model, that platform could in theory be used to look for antifungals or look for antibacterials or look for chemotherapeutic agents. And the university typically wouldn't want to tie it up with one licensee or optionee that was focused on antifungals, thereby precluding the use of the platform to try to develop chemotherapeutics or antibacterials.
And maybe I'll make one other note about the IP ownership. So I said that ownership of IP is really tied to the who invented the
claimed invention.
Yeah, right. Which personnel invented the claimed invention. So I wanted to just make one additional note about inventorship. As you may know, inventorship is a legal determination. It's not the same as authorship on a technical paper, and the standard for inventorship is which personnel contributed to the conception of the invention. So that's going to be an important consideration about IP ownership that comes out of collaborations with startups.
And as usual, Laura is choosing her words very carefully. You've probably noticed that she used the word personnel a couple of times. There's a lot of discussion now about whether AI can be an inventor. Obviously, AI is not personnel, and the rule around the world at the moment is that AI cannot be an inventor. So there can be no patentable invention without one or more people being involved. There has to be an inventor. AI cannot be an inventor. That doesn't mean that the discoveries that would naturally flow out of a platform technology are not going to be patentable. It just means that you need to think more carefully about the inventorship assessment.
Next slide. Great. So Dana spoke earlier about patent eligible subject matter and how algorithms, pure algorithms, are not patentable in the US. So, you know, there's a lot of challenges with how to protect this type of invention, and you know, US law differs from, you know, it doesn't always like line up exactly with how the rest of the world approaches these questions. And then let's see, we talked about protecting algorithms, or sorry, platform technologies with trade secret. The benefit of trade secret, of course, is that it's indefinite. There's not like a 20-year expiration like there is with patents. But as Dana also discussed at the beginning of the call, there's some risks with trade secret, namely someone else can develop it independently, and then it's out there in the public domain. But also importantly, from a university context, protection by trade secret jeopardizes university ownership when federal funding is used to develop the invention under the Bayh-Dole Act. And so we can also consider other types of IP protection to protect platform technologies, such as copyright, trademark, and trade name. And I would call them complementary. They don't protect, they don't provide the same type of protection and in the same way. So they're, you know, complementary strategies.
Copyright can be used to protect source code, for example, so the software itself. For patenting, you would need the software mounted into a CPU at a minimum in your claim strategy. Okay, next slide, please, if you're ready to move on, Laura.
Yeah. Yes.
Okay, so now we're trying to tie it all together and bring it home with a discussion of a platform technology hypothetical. And the inspiration for this came from CRI, so we'll walk through it. And then I think we're going to have a question and answer session if people are interested. So I'm just going to read this aloud, even though that's a rule that you're not supposed to do that when delivering PowerPoint presentations. But let's talk about a startup that has an option from the university or signed some sort of memo of understanding that grants the startup access to the platform technology developed at the university and the base algorithm, with the expectation that the startup is going to develop that commercially. Then the startup drops the option. This happens sometimes. In this scenario, there's going to be some question about their intent. And instead of converting it to a license, they just keep developing the platform technology or the algorithm without the university. So during that time, the startup also happens to get external funding, and they do some work at the university. What happens then? So some of these risks can and would be managed by careful agreement drafting by the university, among the university and the startup. So we talked before about how a startup or other business entity can fund work or research at the university. The principal mechanism, again, there would be something called a sponsored research agreement. These agreements typically specify the type of research that's being funded, the PI at least, who will oversee the research at the university. There's funds coming in to cover overhead, cover the costs of materials, cover salary, for FTEs involved. And there will be intellectual property terms that give the sponsor rights in any intellectual property technology that's developed as a result of the sponsored research. So that can be an option to license new inventions. It can be an option to know-how that's developed in the course of the sponsored research. Also, as Laura alluded to, the sort of complementary IP, there can be copyright, trademark, etc. licenses. So there's no inherent risk to the university associated with sponsored research. In fact, most universities are very eager to attract sponsored research. There just needs to be an adequate agreement to protect the university vis-a-vis the IP, and also, as Laura noted, to enable the university to maintain its tax-exempt status. Now, with respect to having dropped the option or license and continuing to develop the algorithm, the agreement between the university and the optionee or licensee initially should have terms that extend beyond the termination of the agreement. So there would be certain terms of, say, confidentiality obligations that would extend even after the option wasn't renewed, let's say. But the principal protection here for the university is the patent applications that the university would have filed in the first place, which would have been part of the option and would have been owned solely by the university. So if the optionee walks away and the university thinks that the optionee is continuing to practice the patented technology without having an option, then the university has to explore what we think of as enforcement mechanisms, basically telling the optionee, you have to stop, you no longer have these rights, we own this IP, and unless you renew or take a license, you just have to stop. Most small companies will respond favorably from the university's perspective to that sort of an approach. If there's an issue of lack of funds in the startup, then the university will be creative. I mean, the goal of technology transfer is to transfer technology, and by being overly aggressive with respect to financial terms, that can sometimes be thwarted. The fact that the startup in this hypo is getting federal funds, I think, creates a little bit more complexity, but one would need to, the startup itself would need to worry about that, not the university. So I think, unless you have something you'd like to add, Laura, that ends the formal part of the discussion, and we're happy to entertain any questions. Please.
So if anybody has any questions, please, you can ask them directly, or you can put them in chat and we can ask them for you. So to get us started, go ahead, please.
Yeah, hi. Thank you for the presentation. Very, very useful. And maybe this is a little bit of a naive question. When you talked about ownership of IP and personnel, when it comes to university owns IP. So within the university, there might be PIs and students who are the actual and physical inventors, but they are not recognized as owners of that IP because they fall under the umbrella of the university. Am I understanding that correctly?
Yes, by virtue of an employment agreement, for example, faculty would have assigned their rights in the invention to Northeastern. Same deal for grad students or postdocs.
Yeah, and if you're wondering about financial or economic participation later in the process, technology transfer offices typically have a system set up, and I don't know the details of CRI's system, but the typical arrangement is for any licensing revenue that comes in, first the university's patent expenses are taken from that, and then the remaining royalties or licensing milestones, for example, are divided according to a transparent formula, typically between the university, the department in which the inventors reside or resided, and then the individual inventors. So even though, as you pointed out, Lydia, the inventors are not the owners of the IP, they do ultimately participate in the economics when the technology is a success in the marketplace.
Got you. And just a follow-up question, I've heard that in terms of undergraduate students, it's different for them. Like an invention that comes from an undergraduate student, they actually retain the ownership of that. Or is this not accurate?
Yeah. So I can jump in here quickly. Lydia, thanks for the questions.
Thank you.
So that is so it just depends on where the IP is originating. So you're right, like if it's just an undergraduate student who is doing it on their own time and stuff like that, that's not Northeastern owned. But if it's like in a university lab where like an undergraduate is supporting a federally funded project and they're working to support that project forward, right? It's not they're doing their own thing, then that would be part of the invention disclosure process to Northeastern. And then we do have a well-defined IP policy, which also I have posted a link because we have different campuses, so they may be a little bit different. It also goes into how the revenues are distributed. So it has all those different sections and everything is listed there. So I think that's good.
Thank you.
Anything else? All right. So I think I have a few questions to get us started on this very specific. I like the last example a lot. I have a few questions related to that, right? So first is, how is inventorship determined for software? For a patent, it's clear, right? If like it's the claimed patent, right? Issued claims, we can go by that. But how to determine it for software?
So VS, does your question presuppose that the software itself is not patent eligible? You're simply asking, how do I allocate credit for something that is unpatentable?
So what I'm asking is, right, so if the example you started out with is like the predictive model. So maybe there are some therapeutics or something it can predict, like a drug combo, and then in parallel, it's like maybe some model. So the model as such may not be patentable, but we will have a copyright on that. So right? So then it kind of goes into both of those directions, right? So what if we go through this patenting process, it keeps running into these one-on-one challenges. In the end, we are only left with copyright. So then the copyright was an option to the company, then the option went away, but then something, right? So how if we look at these discretely, how is inventorship determined for, say, like software? Versus the patenting part is clear, right? So if you don't have an answer which is clear, that's fine too. I just was curious.
Oh, we always have an answer. So as you may know, copyright is a very strong IP right, and it has an extremely long term. People say, they teach us in law school, that Mickey Mouse is the reason that copyright has such a long term, that Disney is so wealthy and so powerful that they were able to influence the copyright law. So the copyright will extend for many, many, many years beyond what a patent term might have covered. The agreement between the university and employees, again, leaving out undergrads, as you just explained, VS, vests ownership in original works of authorship in the university. If you have a faculty member or a grad student or postdoc who creates an original work of authorship fixed in a tangible form, e.g. software, the university owns that and will for approximately 100 years. You can enforce, if you register the copyright, it's very easy for you to enforce it against the startup company that is using it without authorization. If you don't, it's more complicated. However, and I'm not a copyright attorney, I believe that you can register a copyright after the infringement has taken place and then assert the registered copyright against the infringer, for even covering their past acts. So I guess that's the answer. The university owns the software to which you alluded and would have to make a decision to enforce. Now, perhaps part of the question is, well, how do we prove that someone is using the software when they're not doing it in a publicly visible way? And this is one of the issues with all sort of protection for methodology. You can't know what people are doing behind closed doors. However, if you have a reasonable basis for a suspicion that they're using the copyrighted technology, that would be enough for you to go to court and start the process of forcing them to comply.
So are there any advantages for startups to make sure that all of this, their IP ownership and licenses are taken care of so that there are no such issues, right? Where there is some sort of question like whether it came from the startup or the university. So are there benefits for startup to make sure that all of this is clean so that when there is money, the investor doesn't have to go through any issues and all of that, or if there's an acquisition down the line, if the startup is successful, then this ownership and a lack of license could cause some issues with that acquisition or investment.
Well, you're absolutely right. And this is really critical for the startup. Any fundraising round is going to involve due diligence by the investors. And the more money that they're considering investing in the startup, the more comprehensive will be the due diligence. For any life sciences or technology-based startup, the intellectual property is one of the three most important things. Laura and I work with venture capitalists regularly. I hear from extremely well-financed venture capital groups that the three most important things they look at in deciding whether to fund a startup are IP, the personnel, and the technology. In other words, what's the market opportunity with the technology? So if the IP is a mess, VS, just to really go to the bottom of your question, they're not going to make an investment. The investors need to have absolute certainty that the startup has the legal right to practice the university technology. They need to be sure that the university is not going to sue the startup as soon as the startup has, a lot of money in the bank. And there's no path to effective commercialization over the ensuing 5 or 10 years if there's a unclear IP aspects to the proposition. So it's really critical. If you're an academic researcher and you want to transfer your technology, say to a startup that you're going to be one of the founders to, you really need to make sure all of this stuff is buttoned up properly from the beginning, working with VS and the rest of the CRI team. It's not just a pitch to generate, invention disclosures for the university or royalties. Without things being set up properly, it can really just kill a budding startup.
So thanks for explaining that. The other question as a follow-on is, so if we have a patent and it includes, say, several different parties, and there is no agreement between those parties, and each party can practice it non-exclusively, right? And they can license their rights non-exclusively. Is there something similar for software? For example, like if there is, so suppose there was like a starting software then there was maybe some agreement for that, and then that got terminated. But then there is jointly developed software for which there is no agreement in place. So what happens with those things? So if there is no agreement, can each party practice it non-exclusively? Can the university go ahead and license its rights to a different company altogether? Can you just comment about that?
I, I mean, are you saying in this case it would be like copyrighted software?
Yeah.
So it's taking you back to principles of property law. I think, VS, that the patent system is actually the outlier in terms of what you said, namely that if there's joint IP, one of the joint owners in the patent system can license to a third party and not have to share the revenue. I think for any other type of property like copyright, assuming that there's no agreement between the parties, which was your assumption that limits what the parties can do independently, I believe that a joint owner can still license, but they would have to share the incoming revenue with the other owners.
Okay.
But
All right.
again, yeah, go ahead.
Okay. So that's good. And then what if like there is no agreement and the joint owner doesn't license, but they start offering it as a service and they make money off of it? Then would they have to share the revenue with the other owner or for
Yeah,
software?
I think so. I think it's an exception in the patent statute that says that you don't have to share. But really, again, this question, the premise of the question is that there's some gap in the overall chain of title, if you will, and ownership with respect to the IP. And no investor is going to want to put in tens of millions or hundreds of millions of dollars into a startup company where there's some concern that the crown jewels of the startup company can be used by a third party that could just then create a competing entity. Exclusivity is really important here for almost all life sciences and high tech intellectual property. I mean, if you're making a widget that goes into everybody's mobile phone, then of course there may not be exclusivity, and that's fine. But the sort of technology that typically comes out of university labs doesn't lend itself to that model.
Okay, all right. Are there any other questions from anybody else? Otherwise, I have more. So, Lydia or Shana? All right. So I have one more question, and I know we are getting close to the whole hour. So what I want to understand is that, um, so suppose like there's like the data. So the university has a lot of labs that are generating different types of data sets that we do license out. And then what's happening now is that there are these companies that just need the data for one time or a few times to develop their models, and then they don't need the data. So then what happens, like, how do you think of like reach through in this case, or how do you think of like approaching commercialization of these IP rights, right? So they don't need the data set, but they will continue to deploy the models in the products that they are selling.
Do
So
you want to answer this one?
I can if I think I might understand this. So I think this kind of gets back to what we talked about when we discussed licensing technology to a startup for, let's say, studies for just developing for one or two targets. So in this case, we would be talking about non-exclusive licenses that I guess would terminate after, after this particular project is concluded, and so then the ownership of whatever the results are kind of it's dictated in part by the agreement because well, yeah, by the license agreement in terms of like what was Northeastern's technology versus the startup's technology. But it still enables Northeastern to develop these relationships with multiple startups to, increase technology transfer abilities of patented work.
And in terms of the economics, what's really critical, VS, are just the terms of the agreement. In other words, if the university would like to continue to be paid based on the economic success of a model that someone develops using data which only has a finite period of use, then you need to negotiate for that in the agreement in the first place. There's a very important aspect of contract law in the US that basically says that it's patent misuse to continue to receive patent-based royalties after the patent has expired. And that is an anti-competitive practice. But that does not apply in the same way to know-how or trade secrets. And I guess for copyright, it probably applies in the same way, but since copyright lasts for 100 years to an approximation, it's much less of a ripe issue. So you, in representing the university, if you want to continue to be paid after the option or license is terminated, you need to build in royalty obligations in the agreement that are tied to access to trade secrets or copyright or know-how that continues off into the future for a very long period of time.
Okay, so I think we are right at the close of the hour. This was very informative. Thank you. So PJ will send the slides out as well as the recording. She's working on this today. Thanks everyone for their time. If you guys have any last kind of words of wisdom you want to share before we close out, then that's good.
No, just thank you very much for the opportunity. Hopefully it was helpful.
Thank you.
Thank you.
Thank you.
Bye.
Okay,
Thank you.
bye-bye.
Bye.
Take care, everyone. Leave?
Yep.